Good evening, friends, and happy Makara Sankranti to all of you. Whatever name you call, Pongal, Sankranti, and so on. We are gathered here today to have some preliminary glimpse to a framework which we have titled as DGPSI HR, meant for the HR applications basically, and also to assist organizations which have predominantly HR operations, because we have come across many manufacturing companies with whom we have been discussing DPDPA compliance. And if you look at their profile, if they are a B2B kind of organizations, they don't have customer data at all in their portfolio. They have, of course, employees data, and employees are also coming under the DPDPA, but there is no customer data in them, except, of course, some special circumstances in which they acquire customers' data, like when they have a retail showroom or something like that, company-owned retail showroom. So we thought that we are burdening such companies with too much of compliance requirement, and we need to look at something different. Secondly, the HR actually presented its own complexities, some of which I will try to discuss today. So we thought that we will perhaps develop a framework which will help companies to be compliant with DPDPA in addition to whatever we have earlier done. As of now, if you look at DGPSI as a family of frameworks, we started with the full version, which is the 50 model implementation specification version. Then, of course, we brought out a lighter version called FDPPM DGPSI Lite by reducing the number of implementation specifications to 36 and making it directly clause by clause compliant with the Act. Then this year, 25-25 end, we added the AI portion, which was actually an extension of the DGPSI full. It is not an independent full framework, but DGPSI AI with 9 implementation specifications was meant to assist the data fiduciaries who are already adopting DGPSI full version. Then recently, we have tried to further expand the DGPSI family, in which we have taken DGPSI GDPR as a framework to be compliant with GDPR. Now we know that until recently, GDPR compliance was being achieved with the use of ISO 27701 2019 version. And now, of course, the 2025 version has come. So we thought that many of our Indian clients have both processing of Indian data as well as the GDPR data. And therefore, whenever we have any client, he normally either says that I am already GDPR compliant, or I have GDPR data, I don't know what to do. If I do DPDPA compliance, will it be sufficient for GDPR? Or if I do GDPR compliance, will it be sufficient for DPDPA? This kind of questions keep coming up. So what we have tried to do is to develop an additional kind of a version of DGPSI exclusively for GDPR. At some other point of time, we'll discuss this. Other than that, recently we introduced this DGPSI HR and DGPSI for data processors. Now, in November, when we held our CDPODA program in Bombay, there is, I think GDPR we discussed, but HR and DP was not yet ready. So I thought that we need to upgrade our trainees of that batch to our recent thinking. Subsequently, in December, of course, we did some program in Bangalore. Of course, one was a virtual program. where I think we briefly discussed the data processor and the HR, which slightly further refined as I'm going to present in this set of presentations. In future, when we have additional programs, we will perhaps try to discuss it in greater detail. Now, I suggested these two, that is HR, the DGPSI HR and DGPSI DP. And today we will complete DGPSI HR. We need to find another day for DGPSI data processor. Maybe we will find and schedule a time for that. Another 1 hour session. I am not trying to clash with the JVS which we are having on Wednesdays. So that's why this we thought of doing it on a Thursday. And next Wednesday we have a JVS. So again, if we are going to have one more session on data processors, we will try to have it on a day other than Wednesday evenings. So that is the background of this. I'm sure most of you are aware of FDPPI, but for a few people who may not be aware of FDPPI, FDPPI is a Section 8 company which is into privacy and data protection in India since around 2018. We actually started in September 2018, and we are running our certification courses. We are also having our own implementation frameworks, unlike others. So that's why we are proud to say that we are having a framework which is made in India. Okay, so that is our hallmark. Okay. Now, as I was telling, DPDPA applies to all companies, whether they are big or small, and to different sectors. Now, one category of people I have indicated is this manufacturing companies who may not even have retail sales. There are many companies who actually are suppliers to defense, suppliers to other manufacturing companies, the so-called ancillary industries, who do not have individual customers. They only deal with another organization as a customer. So their exposure to DPDPA is somewhat different from the exposures which companies which have direct consumer sales are running an e-commerce kind of an operation phase. So that is one category. Now, they may not have the personal data of the public, but they are all persons or organizations who have employees. Now, employee data is, of course, personal data. And within that personal data, of course, you may have pre-employment data and sometimes post-termination, some people's data which remains in the organization. And DPDPA has made a reference as one of the legitimate use considerations that for employment basis, you may process data without consent on a legitimate use basis. But even when you have such processing without specific consent, you still are open to the other requirements of DPDPA, including security and other aspects, including the data breach reporting and other things. So we have all organizations, almost 100% of organizations, excepting a few single-man organizations, they are all exposed to DPDPA because of the employee data. And we thought that we will try to address that requirement exclusively in a separate framework. Additionally, there are also some specialized organizations who provide HRMS services, payroll services, and the whole HR field is full of such service providers. Now, the service provider himself is a platform owner. Most of the time, he is a joint data fiduciary, though many times we try to look at them as a processor. So there is a set of people who require a HR specific compliance framework, which I think this will try to help. Now, this framework has 27 model implementation specifications, and there could be a few who may be handling public data because of the CSR activities, sometimes exhibitions, factory visitors, and as I said, pre-recruitment, post-retirement. But these are small aspects of the total data and can be handled, in my opinion, as a project of a particular kind. And you can have compliance measures based on that particular project. In fact, many companies may even be able to use the services of event managers, and they are already perhaps using event managers, and they can try to see how they can reduce their compliance requirements. So rest of the people who have a lot of HR activities, I am trying to bring them under this particular framework. Now, our objective in today's discussion is that we are anyway considering DGPSI as an open source framework. So we want to discuss it with people like you, and we are also proud to say that the entire DGPSI framework is being developed by the professionals themselves. So when I'm presenting this to you, and probably when we have more discussions, I'm looking forward to your contributions to fine tune the framework to the extent necessary. But the idea is that we will not approach DPDPA compliance blindly. We will have a framework, and it's always better to have a framework and then make corrections to that rather than going blindly. Okay, with that, we'll look at these 27, what we call as model implementation specifications. Those of you who are aware of DGPSI, we know that we have this model implementation specification, but we leave some flexibility to the organizations to create what we call as a deviation justification document. And if they feel they need to make some modifications, they can document that requirement through the deviation justification document and convert this model implementation specification into a management approved adapted implementation specification list, which will be the implementation charter for the DPO or whoever is taking the responsibility. Okay, but from the side of the framework, what we are presenting is what we are calling as model implementation specifications, which are the desired kind of requirements. Okay, now to start with, the first implementation specification is to ensure that there is a proper governance mechanism. So we are looking at designating a compliance manager. We have not used the term DPO here because unless the organization is a significant data fiduciary, they don't require a designated DPO as a mandate. And if any organization is having only employment data, or we are using this framework for the HR division of a larger organization, then we may not require a DPO for this implementation. We are looking at a compliance manager, unless, of course, the organization takes the freedom to designate that person also as a sub DPO or whatever is that. Okay. But that compliance manager should have necessary credentials, and he should be provided support in terms of people, budget, technology, and wherever necessary, an external consultancy so that they are able to hold on to the interpretations which will emerge as we go forward. Now, in addition to this, one single person who is the person who is accountable, we need to have what we have called as data governance and data protection committee. If it's a larger organization, you may already have such a committee, so you may not require one more. You may have a subcommittee or part of that functioning as this Apex organization. We feel this kind of a committee is required with a representation of a board member there, so that any major policy changes will have the approval of the top management. Now, in order to guide this data protection committee, you may need to have a comprehensive data processing policy. which is applicable to the organization. So this particular policy is different from the privacy notices. Okay. In fact, in many of our client engagements, we call this as a manual. We actually provide a DPDPA compliance manual, which actually codifies the entire requirement of DPDPA compliance. And separately, for each process, there will be a privacy notice. So other than the privacy notice, there can be an organization-oriented data processing policy. And obviously, there has to be issues such as data audits, whether data audits have to be done internally or externally, whether you should have something like, say, data valuation. All these things you can look at in this governance of framework. Then second most important thing, which is also a common thing, in GDPR we are used to the terminology of ROPA. This is similar to that. We call this as an inventory of processes, because one of the basic principles of DGPSI is that we try to attempt process-wise compliance. We actually break the whole organization's activities into multiple processes. When I say process, it is a process in which personal data is being collected, stored, processed, disposed of in whatever manner. So that kind of process, we try to identify multiple processes within the organization and identify a process owner, so that within that process, we will be able to understand what kind of data elements are required and how long you need to retain. So all these principles of data minimization, data collection, retention, etc., can be directly linked to the purpose, which is linked to the process. So the idea is, for every purpose, there has to be a process. So when we start our exercise of compliance, we ask the organization, please try to make a list of what are all the purposes for which you are processing personal data. And that question actually goes to all the stakeholders in the organization, including your marketing person, including your finance person, and so on, so that we will be able to have clear, say, collection of purposes for which an organization is processing personal data. Otherwise, if we just ask one person who is designated as a DPO, he may or may not be able to fully identify what are all the processes which are occurring in the nooks and corners of the corporate entity. So we feel that by creating a process-wise bifurcation of the operations and then identifying a process-based leader, we will make him responsible to identify what data is to be collected for that particular purpose, what is being collected, and so on. Particularly when we are talking of legacy data, we don't know how long we have been collecting the data and where all it is lying. So at least by bringing down our focus to a particular process, we are in a position to identify the legacy data which is lying in the organization much better than just relying upon one person thinking that he knows everything about the organization. So this process-based compliance is an important principle. So we want every organization to have a list of processes throughout the life cycle of the HR operations, and each process will have a description, will have a unique ID, will have a process owner, have an identified purpose, then required data elements, and so on. Once you have that identified purpose, you know what is the privacy notice to be given to this particular process. So the privacy notices will get separated, and then even the access control becomes easy to identify, because only those persons within the organization who are associated with this particular process will be given access to this data. And if we have the data of one data principle which is having multiple data elements, we can identify which of these elements are relevant for a given process. Therefore, we are able to even ensure that we are not going to say that this particular customer, um, all data of this particular customer will be associated with one processing team. Each processing team will only access that amount of their personal data elements which are relevant for their purposes. For example, if you are having a company which is, let us say, food delivery, Zomato kind of a people, yeah, one way of looking at it is one process is food delivery system, let us say. Okay, if you define it as food delivery system, it will include receiving of the order, collection of the payment, and then having a partner for delivery who goes and delivers. So all these multiple activities. What we feel is that you can bifurcate this into multiple processes. For example, collection of money, you can segregate. That team will collect all the financial data. This logistics person, most of the time, who is an external courier or somebody, he is only given certain information such as where he has to deliver the packet or something like that. So by bifurcating this, you are reducing the data requirements to be shared with the different teams. So maybe you may say that I already have 100 processors. You are asking me to break that 100 into 300 processors. But I feel that it is still worth, because you will be able to have this data minimization, data retention, etc., more accurately when you have this bifurcation. For example, in this food delivery, this thing, this logistics management person doesn't require to hold the data beyond, say, 24 hours after the delivery. It will be only to take any disputes about delivery or something like that. Rest are so that data with him can be deleted or removed immediately after 24 hours or 48 hours. Whereas the finance aspect of this transaction becomes something which needs to be held for a much, much longer time, because there is a financial interest involved. There may be other requirements. So that is only an example I'm going to say, and we are saying that that is one of the ways you have to create an inventory that also applies to the HR. For example, the HR may have, let us say, payroll processing, it may have recruitment, it may have background processing as a different this thing. It will have some, say, travel arrangements to be made for employees. So these are multiple processes associated with the HR itself. There may be a disciplinary committee which is looking at that. There may be an incentive management committee which gives some rewards. Now, each of these can be considered as different processes and handled. That way, it will be easy to identify what is the data you are having and so on. So that is the second MIS. And where there will be some public data which will come in is when you have these welfare schemes for families. And when we say a family, we are talking of the family of the employee, which may even include minors. So that kind of thing, insurance, these are things which needs to be handled as a specific project. Now, after having this process inventory, then we go towards the data inventory, that is the MIS 3. The organizations have created inventory of personal data, in this case related to HR operations. So this will actually be an aggregation of the data of each of the processes. So the accuracy of this data inventory system will be better because we go from the process. This is slightly considered better than running a software across the whole organization, trying to fetch what we call as the DPDPA protected data from all the systems. That is always subject to inefficiencies. Whereas here, because we are asking, let us say, 50 process owners to identify what are the data which you are processing, maybe the possibility of missing some data is much less here. Okay. Now we come to one significant part of the HR operations on which I have been having some detailed discussions also. This is regarding handling of contract employees. This is a slightly complex situation. I am not sure whether I would have covered all the aspects required, but I think this is an area which creates a problem for most of the organizations. When we say contracting employees, what will happen is one, we may be consumers of employees provided to us on contract by other placement agencies. Second, we ourselves may be a placement agency placing our people in multiple organizations. Third category, which has become relevant now, is that our employees whom I am placing with another organization may themselves be contractual employees with me. I hope you are able to make a distinction of these three categories. That is, an organization which employs, of course, the employees are one category which is covered separately. Now, there is a set of employees whom I am placing with other organizations where they are going to process personal data of that organization. Now, the question is, what will be their responsibilities? Are they cannot be considered as my representative because I am not the person who is giving them the personal data. I am placing them in a particular situation and they have got employment obligations with me. But under my employment, by design, I am providing them confidential personal data belonging to that client organization, and they have to follow the instructions of that client organization. Now, the client organization is a data fiduciary, and they are letting a contractual employee to handle the personal data. Now, there has to be an appropriate contract which defines this kind of relationship. One contract will be between the organization A with organization B. Second contract will be between the organization A and its employees who are contracted out. Now, this is where the compliance becomes little complex, and I'm sure legal departments will have to work overnight to get the right contracts in place. Okay. Now, my problem in terms of compliance is to identify who is a data fiduciary, who is a joint data fiduciary, who is a data processor. These three roles get mixed up in this role, and we have provided MIS 4, MIS 5, and MIS 6, three implementation specifications to address these three categories. Now, if you have any questions on these things, we can spend a few minutes on this because this is one of the difficult parts of the discussion. Okay.
Sir, what exactly is this incoming and outgoing
Incoming
roles?
contract employees is I am the user of employees provided by another placement agency on contract basis, not on recruitment basis. I'm not talking of background people or recruitment companies. When they do processing, ultimately they hand over the customer to me directly, they become our employees. Okay. Now, suppose I take these employees on a project basis, they remain the employees of another organization, but I am using them. They are my incoming contract employees. Outgoing contracting employees is when I sit in the role of that placement agency, okay. I recruit people as my employees, pay them whatever compensation, I pay them on a monthly basis and I give them the PF benefits and all that, this thing. But I tell them, you go and work in such and such a place. I will have a business to business contract with them and I will collect some lump sum amount separately. Okay. Their employees are outgoing contractual employees in another organization.
Yeah. So basically, I'm hiring somebody who are incoming contract employees. Likewise, I'm letting out my employees to another organization as an outgoing contract employees, basically.
Correct. Correct. The third category comes because when I am letting out somebody, that employee who is let out may not be a employee, he may be a gig worker kind of a thing. Okay. I myself don't have a contractual, employment relationship with him. He is a contractor with me. Then I tell him that you go and work in some other place. So it is like subcontract. Are you able to capture this thought? This is what people are today calling as gig workers. Okay. Now, there is these individuals work on a contract. One of the areas where this is very visible is the hospital industry, where there are surgeons, medical professionals who work for a hospital. The patients come from the hospital, but these people provide the service on per surgery basis or whatever is that. They are not employees of the hospital. They are independent consultants. Now, how do you build the relationship? They have personal data. In fact, they themselves create personal data and hand it over to the hospital for documentation and records. And that will be stored by the hospital, shared with the patient and shared with the diagnostic center and all those things from the hospital. But this consultant is the person who has to generate that particular data, and therefore his role is more like a joint data fiduciary. Am I making this point?
Yes.
So, in Karnataka, in fact, today I have posted an article in Naavi.org where I have quoted the Karnataka Platform for Gig Operators Act. Okay. Karnataka has passed an act exclusively for the platforms like your Rapido platform or something. They have also added the health services. Maybe they are looking at Practo kind of a thing. So there is a law, at least in the state of Karnataka, which defines a gig worker. And a gig worker is a person who works on a contract basis from project to project. There is no guarantee that you are going to give him projects for the next 1 year or something like that. And remuneration is based on individual projects. And this person will be raising an invoice on me. An employee will not raise an invoice for his monthly salary, whereas this gig worker will raise an invoice on the a company which provides him the contract. And in the income tax returns of this particular gig worker, he actually projects this as income arising out of his contract, which is actually a kind of a business income. It is not an employment income. And our income tax law recognizes that even if the filing of the income tax is in the personal name, not necessarily in a corporate name. So individuals can do business in their personal name. Okay, that is what we call as a proprietary business. Now, always we have this confusion how to deal with the information of a proprietary concern. Is it personal information or is it business contact information? Now, in the case of gig workers, this comes into focus because this individual who is an individual, so his name, his contact address is something which looks like personal data. But he is doing a business with me. He is not under an employment contract with me. Therefore, this gig worker's data is all business contact data. And that is further validated by the fact that in the income tax returns of this gig worker, this goes as business income, not as salary income. So now we have this kind of transactions in the HR arena. We need to manage this also. Am I correct? Yep. Ramesh, you have any Disagreements?
No, we're perfectly following you, sir. Perfectly fine.
Okay, this is a new concept.
Yes.
Okay. In fact, I was having some discussion about this, and somebody was telling me, you cannot have an individual who will be a data processor. Okay. I asked a counter question. When an individual can be a data fiduciary under DPDPA, when he is processing the personal data for business purpose, why can't an individual who is processing personal data for business purpose as a gig worker be called either a data processor or a joint data fiduciary, depending upon his responsibilities? If I am making him do only things which I want and I am determining the purpose, I am determining the means, he is only executing it, then I can call him as a data processor. But if he is like a medical, this doctor consultant, okay, he decides what treatment has to be given, he decides what surgery has to be done. And I am a hospital, I am not going to give him professional instructions on how to conduct a surgery. So therefore, in this, the means of execution of the contract is entirely with that consultant. Therefore, he must be considered as a joint data fiduciary. So there could be both this joint data fiduciary and the processor type of contracts, depending upon the details of the type of work which this contractual employee performs. Okay?
So, sir, if I want to draw the parallel for a consulting company, then virtual CISO and virtual DPA will also fall in the same category of a doctor, right? Because a virtual CISO might be doing work for multiple companies, right? And he may have access to personal data of the employees of the company that he visits or works. Maybe remotely also he might be working.
Correct. See, like he has to wear multiple hats. Of course, he has to ensure that he doesn't mix up one data of one company with the other. That there are all the ethical issues which he has to manage. Okay, but yes, it is what you say is correct. He is actually a kind of a contractual worker who develops that kind of data processing service.
Ramesh, I think you are unmuted. Ramesh, you are unmuted. Mute. Ramesh.
Okay. Yeah, Prashant.
No, I think there is some background voice. I think Ramesh is unmuted and talking.
Yeah. No, he's not listening to you, so.
That's fine.
Okay. Okay.
As long as you are able to hear me, I'm fine. Yeah.
Yeah. Okay. So, Prashant, is this thought process okay?
Yes, absolutely.
Okay. See, one thing we have to remember is that there are some new thoughts which we are talking of, and that is why I always say that these are jurisprudential thoughts. Okay. That is, maybe it appears new, but we have enough capability to debate amongst ourselves and accept what is correct or what is not correct. So that much of confidence we need to have in saying that this is also a way we can think. Immediately there will be resistance. Others will not agree. Okay, but we need to actually ensure that this concept is built on some solid.
But sir, looking at how contract management between entities work in India, I see that after DPDPA data processor and data fiduciary and plus gig workers and contract employees working, this is going to be a gray area and a lot of calibration should happen because nobody exactly knows. For example, one of my colleagues, Vidula, she works for a company for last 3 years and she visits them thrice a week, right? And she has access to all their data because she faces audit on their behalf. So in that case, it's going to be a very tricky situation how to draft a contract with them. I have plain contract with them for NDA, but since NDA will not suffice if I look at PIMS 2025 or if I look at DPDP Act now.
Agreed. So that's why this is a challenge for contract people who are drawing the contract also. I don't know how many lawyers are here.
course, I'm one of them. I don't think whether I think Sandeep had joined today or not.
Okay, so this is an area where some more research needs to be done and contracts will have to be drafted. Yeah, Govind, Govind, you have got any thoughts on this?
Yeah. I think Govind sir, your inputs, please.
Sir, I mean, I've been listening to you. I am rather a student here instead of, I mean, an interlocutor.
You are being modest.
You know,
You are being modest.
Yeah, so Naavi sir, there is one question. I mean, that was popping up in my mind. The the staffing industry has incredibly large layers. There are even something like about fifth in the supply chain. Okay, all some of them, they give only the labor. Some of them they give directly their employees. They contract and give. They give their own employees, and and ultimately there is an ESI PF consultant separately who manages only the ESI PF, whereas the ESI PF Act says that it is only the employer who is responsible, and it also lays down specific obligation on immediate employer. Okay, this from the legal context, who ultimately may be held as the data processor, data fiduciary, joint data fiduciary in a ironclad manner so that it works within the legal framework. This needs to be probably be brainstormed by us, because at some point of time the board, data protection board, or even the one of the courts may decide one way or other, which we have not probably thought of even. Can you please throw light on these particular issues, sir?
I agree. That's why these 4, 5, 6, 3 implementation specifications for 3 different kinds of situations. One where is an employee who is given out. The next is contractor given out as contract, and of course the recipient. Okay, so if there are more number of sub categories, we have to look at that, and we have to identify exactly the responsibilities as envisaged and see that the contracts are drafted properly. At least we are just throwing up this thought. See, when we have this framework and present it to people, people need not necessarily agree with everything which we are saying. Okay, anyway, we have said that you can have a deviation justification document if you want. But the idea is that you start thinking on this. That is the same thing which we started doing with the data valuation. We said data valuation is recommended. Now, how to do it and other things we have to find out. Now, actually, the Controller and Auditor General has asked all PSUs in a mandatory direction for audit, saying that you should all have a fair valuation of data assets. So that is the reason why I'm telling PSUs, start thinking about what is data valuation. Okay, that data may be both personal data, non-personal data, and if it's personal data, there may be so many categories. If it is non-personal data, also there may be various categories. And the non-personal data valuation for a private company may be different from a public company. So this has now come forward as a point of discussion 4 years after we started looking at data valuation. Similarly, this also may require further discussions, but I think the framework will throw up this question. Let the company try to find solutions, and there are other experts like you who will also be debating on a context to context basis, determine how to handle this kind of a difference. Am I correct? Okay. We will leave.
Sir,
Yeah.
Let me add up only one supplementary question here. See, if the end user of a human resource makes a very clear contract on the supplier, human resource supplier, contractor, telling that very clearly that the compliance, the obligation of compliance to DPDPA Act is squarely resting on you. Okay, so any penalty, any default, anything from the obligations perspective will be borne by you. Okay. So what happens in this case from a legal perspective? Can the end user can wash off his hands saying that it is the contractor who is responsible because I am contracting your employees only and I have nothing to do.
Okay, there are two aspects here. One is who is determining the purpose and means. Okay, based on which the law determines somebody is a fiduciary or data fiduciary. Second is, in any contract, you can always have an indemnifier, a guarantor, a cyber insurance person. So, if I am saying that you have to take the liability and if he agrees, you can say that it's a counter contract on liability management. Okay, I may be still a joint data fiduciary, but you agree to underwrite my liability. You can look at it like that. So the law has defined data fiduciary and a processor. Data fiduciary is a person who has the purpose and means. And if either the purpose or the means is also jointly determined by the second person, he becomes the joint data fiduciary. Then the third category is data processor, who doesn't determine the purpose or means. He just follows the instructions as a subcontractor. Okay, this is what the law says. Now, if you say a processor will guarantee some liabilities, it becomes like a kind of an indemnification which is voluntarily giving. Okay, so I think that's where it is like in many of the cloud contracts, you purchase a software, your data gets processed in that, but the management of the data is done by that platform provider himself. So in that case, there is one contract where the platform is licensed to me, second contract where I give back the data for him to store, manage, etc. So there's one contract has got two subcontracts. Same way, what you are suggesting may be considered as a combination of two counter obligations.
So in the case, can there be two joint data fiduciary in respect of a single person?
Possible?
Okay. Okay. It's a complicated, complex situation.
It gets complicated, but I'm only saying that start thinking about it and look at the particular context and then draft a contract properly and make both of them understand that in this particular context, this is how you have to share the responsibilities of compliance. Okay.
Thank you, sir. Thank you. Thank you.
If you don't raise this question, people will not understand this at all.
Naavi sir, on the topic that Govind sir has raised, I think Samir may have some input because he is the person who handles this kind of situation day in and day out. Samir, you want to say something on this?
Not today because my throat is not that great.
Okay.
I'll write and I'll send. I agree. We face this every day.
Keep thinking. We will perhaps have other occasions in which we will re-debate this. Okay.
Yes.
Because let us digest this and then perhaps move ahead. Okay.
Yeah, sir.
Yeah.
Let me present some different scenario. See, I'm a bank. I'm a data fiduciary. So I'm just presenting about the non-employees. So one category of non-employees I have is the resource person will come, sit in my premises, work for my orders. That is one category.
Yes.
Second category is non-employees. They don't come to my premises. They sit in their office. They work for me as per my instructions. Now, there are two categories. Third category, there are people who work only for a part of the month for me, not the full month. For example, chartered accountant. They say I engage a chartered accountant for a firm. There are three people who look after my requirements. So these are the different scenarios. The non-employees going to touch base a fiduciary for different purposes, and everybody has exposure to my personal data processing activities.
Agreed. You have to take care of those things, and of course, working in the premises or outside the premises is something which is like a remote operation, like work from home kind of a situation. That becomes another element to be added in the contract perhaps. Okay. Yeah. So let us move forward. Okay. Some of these things are simple, creating an awareness and commitment. I add the word commitment because after doing a training, I need to have an ethical declaration signed by the employee. Then only I say that some commitment is there. So that is the MIS 7. Then now we come to the category of legal basis. Now, one MIS is first, now we have already classified the operations into multiple processes. Each process has got a purpose. Now, legal basis for the purpose may be either it is totally exempted because of section 17 or it may come under legitimate use. If neither of this is there, then we get into consent. So before we get into consent, we suggest that you develop a kind of a policy document associated with each process to tell the process owner, your process is exempted. Your process comes under legitimate use with these sub-conditions or something like that. If neither of these two are there, then your process comes under consent. Then you go into the consent management situation, where of course we are having the issue of purpose-specific privacy notices and collecting the consent as a kind of a contract with proper authentication. So that is the consent part, MIS 9, 10. Now, because legacy data is relevant, now privacy notices should be sent to all the legacy data. So that is part of the consent management. These are things which we have already discussed in other DGPSI frameworks. Now, authentication is also something which we have discussed. What we mean by authentication is that the consent, that is the acceptance of the privacy notice, has to be authenticated. Now, in the case of HR, it is easy to have proper authentication because we are dealing with our employees. So they can either digitally sign the document or otherwise, because our relationship is also for a long term. It is not like one fleeting customer who will be downloading my app today morning and afternoon he will be deleting it. For him to have a digitally signed consent is expensive. But for my employees, it is not a problem. So we can use the e-sign kind of a facility to ensure that consents are properly authenticated. Okay. Next set of MIS is the rights management, which is of course the right to access, correction, grievance redressal, right to nomination, etc. Okay. Now another important aspect which we need to discuss is this consent manager. Okay. Now you know the consent manager is not mandatory for the data principal to use. Okay, he can give consent directly or he may use a consent manager. For the data fiduciary, it is mandated to make provisions to accept the consent to a consent manager. But I personally feel that for a HR process, the use of consent manager is not very appropriate because one, you don't expect your employee to transfer his personal data from another data fiduciary to me. Okay, because what I require is specific to my employment, and you might have been employed in a similar organization. I don't want to transfer that data. So the one use case which the Act has referred to is completely unacceptable. Second, for any other operations which I have got, if I say that an employee can give the consent through a consent manager, then the purpose for which he is giving the consent has to be exposed to this consent manager. Now, the purpose may be specific to my operations and it may be something which is like a trade secret. I don't want to tell what kind of consents I am getting from my employees to any outsider, including the consent manager. Even though the consent manager may or may not have the actual data, he knows the purpose for which consent is being given. So in that case, I will try to defend with the trade secret kind of right to say that I will not accept the consent manager routed consent. I want my employee to give the consent directly. So I feel at this point of time, consent manager may not be that relevant as far as HR processes. Let us see if somebody makes a demand, then it should be handled as a grievance. We'll leave it at this because we have discussed this sometimes. Okay. Now, data processor, we will discuss this data processors in detail in the next framework. So we will say that there has to be appropriate security clauses and other things. Okay. Now, MIS 16 is to ensure that any other law, which may be labor law, which may be 88 2000, they all become relevant, and we should have a ear open to what changes are happening there. Reasonable security practice is as per the rules, whatever is given needs to be applied given here. Now, data breach notification is applicable both to the data principal as well as to the data protection board. And if it is necessary, even certain will be required. The same conditions which are there in the Act will apply there. Now, MIS 19 is to ensure that the business contact of this compliance manager is available to all the employees. Of course, here we are talking of employees as the data principals. It may or may not be necessary to put it on the public website, but if there is an intranet, perhaps it has to be given there. If you want to put it in the public website to show that you have thought about this separately, you can do that. That is not going to be a big problem. Okay. Now, valuation, we have said that, okay, we will valuation, I think it has been added in another, MIS. So this is more like cross-border transfer. If there is any cross-border transfer, that has to be organized, and of course, India is yet to define any restrictions on cross-border. Okay. Then MIS 21 is to handle the DPB-related inquiries for which suitable amendments have to be made, which is also there in our DGPSI general full listing. Then MIS 22, 23, and 24 address the DGPSI AI related things like making an AI risk assessment, having a human handler, and then having AI security. So these are things which we feel is also relevant for the HR operations. Then the general acceptable usage, and then distributed responsibility, then documentation. So this is what we have identified as the 27 MIS required. So I will stop here and take further questions to the extent the time permits. Okay. Ramesh, we had muted you in between because you were talking on some other phone. Okay.
Sir, I'm sorry. I was in another call. Sir, now what I understand is that along with the DGPSI Lite or DGPSI Full, right? These specific controls, what you are talking about, is for HR to give a more focus along with the other controls. Is that right?
Correct. And if you are implementing DGPSI full or something, then there will be some overlap.
Correct.
So you can leave it out, handle it accordingly. But if there is not much of this general public's personal data, this DGPSI HR may cover more than 90%. Where I have given some indications of project-based handling of, say, this exhibition visitors or factory visitors kind of thing that can be separately handled. Okay.
Now, why I'm asking is, let's say that one of the control you were talking about providing reasonable security practices, I would have taken care of it.
You would have taken care of it, fine.
Yes. Yes.
There are many such things if you are already implementing the DGPSI. But here what I am saying is, let us make that general manager in charge of HR take responsibility.
There you are. There you are. I got it. Thank you.
Okay. Srivatsa has got something?
Sir, so basically, my question is similar to what Ramesh sir just asked. Say an MNC, a software company MNC, developing some AI tool, do they need to implement DGPSI in full, as well as HR, as well as AI, as well as GDPR flavors? Is that a scenario?
It depends on whether they are themselves processing the DPDPA protected data or not. If they are only handling GDPR protected data, then they have to be GDPR compliant. Okay. And even if the processing is happening in India through a processor, they can try to seek exemption. Okay. Now, if they are handling the personal data of which is applicable under DPDPA, then obviously they become the data fiduciary. You asked the question of an AI developer. Okay. Now, we have discussed this DGPSI AI from the deployer's perspective. If I am a data fiduciary, I am deploying some software. One software is an AI. Okay. Then this AI risk gets transferred to me. And I am expecting that AI developer or the licensor to give me an assurance for which the minimum assurance I am asking for is that you should give me a risk assessment. I will do a risk assessment. You also perhaps give me a copy of the explainability document which you have created or something of that nature. Then accountability, I will have a human handler responsible for the AI. You also should tell me who is the human handler from your side. Third is security regarding this hallucination and other things. So how you have taken care, what are the guardrails? That is what I am going to ask you. You have to give me the assurance. So that is as far as I as a deployer is concerned. Now I am not today talking of the deployment. In fact, if you look at DGPSI AI framework, there are 13 implementation specifications aimed towards the AI developers. So please go through that separately. Maybe some other day we will discuss that. But today we will only discuss about deployers. Rest of it. Now, if the AI developer supplies a AI algorithm and it is a black box kind of a setup where he doesn't give me any explainability, he only gives me functional whatever it can do, then I have the right to ask him, then you please consider yourself as a joint data fiduciary, because the means by which your AI is processing my personal data, I am not aware. You are doing it entirely yourself. You have not given me the code or any other, even an explainability document. So you have to take the responsibility as a joint data fiduciary. So in our deployment contract, I would like that to be mentioned. If it is an open source AI or something like that, on which I know exactly what it will be doing, if I want to take the responsibility, then it's different. Okay, so deployer and developer, please look at them as two different things. And applicability of DPDPA or GDPR comes from what data is being handled by that particular organization. And accordingly, either that act will be applicable or this act will be applicable. There is no situation where both acts will be applicable for the same data set. Yeah.
So that also means that in some other conversation you had been mentioning that we should look at everything based on the process orientation. So
Yes.
basically here also the process orientation comes into picture, and we should look at it in such an organization, whether it's a HR department or a small other department where only DGPSI light could be applicable, or GDPR related process might be applicable, or HR, something like that, right?
Correct. Yeah.
And one other question related to actually the tools, the supporting tools that we are getting to see in the last few weeks, the consent management tool or the data discovery tool. Again, are there any differentiation in terms of these flavors, like full flavor, light flavor, HR flavor, AI flavor, like that?
No,
Are there
right now, tool developers are developing their tools based on their perception of what DPDPA requires. Not all of them are DGPSI compliant.
Yeah.
Okay. Over a period of time, we have to see how it is going to be DGPSI compliant. So we are trying to understand what these tool developers have developed so far. And we have none of that means that if somebody is presenting in a DPPA forum, it doesn't mean that we are endorsing that. Okay. In fact, we are also trying to understand what is their product. But maybe in some point of time in future, somebody works with us closely, then we can see how closely they are able to comply with the DGPSI. Okay, right now it is none of them are mandated to be compliant with DGPSI before they make a presentation to us. Okay. Yeah, Ashok has got something to say.
Yeah, sir. One of the, I think, just off the topic, but the pertinent question that always still remains is if the organization chooses or decides that they are not a significant data fiduciary and consider themselves as a data fiduciary because there is no specific definition of what as to what is the significant data fiduciary. Neither it came in the rules notification that was recently passed. So,
Yeah.
of course, it is a risk for the organization, but the first question is there a possibility that the data protection board is going to come out with something, or till that time we don't know. I mean, there is a possibility that, and there are going to be arguments on that specifically. So I'm
See,
talking it more.
at this point of time, there is no indication that government will come up with a list of activities which can be called as significant data fiduciary activities. So an assessment has to be made by individual data fiduciaries about the risk or the sensitivity of the data which they are processing. Volume is easy, but which can be also very clearly determined. Risk is subjective. So what we have suggested in our DGPSI is that the organization, when they do the impact assessment, the first thing they have to do is, am I a significant data fiduciary? This question they have to ask themselves and create a document. If they feel that no, we are not significant data fiduciaries, if they have documented it properly, it means that they have taken the risk of a bad decision, if at all it happens to be a bad decision. The DPP will come in only when something goes wrong, and when they are making an inquiry, at that time they will say that why you have not identified yourself as a significant data fiduciary, why you have not appointed a DPO, why you did not conduct a DPIA or appointed a data auditor. At that time, you are going to say that I thought I was not a significant data fiduciary. Then it is for the DPB to consider whether that has to be considered as a default and determine what kind of penalty they have to give. See, the very word fiduciary essentially means that you have to determine what is your role. So, to determine that I am a significant data fiduciary or not is itself a responsibility of the fiduciary, according to me. Okay?
Sir, one supplementary information I wanted to share as I worked as a director of ESI Corporation and had some responsibility to write the ESI Act amendment tax also quite some time back. But it's because since it's a HR you are covering, from that point I thought, I mean, that making a large mention is that any law gets matured over time because of litigation. Okay, it is only litigation, repeated litigation matures a law. So now we do not have any case law, nothing, I mean, because it's a very green now. Okay, so in the ESI Act, I think, I mean, it should be the same case in the PF Act also. There is a mention called, there is a legal requirement which people need to which organizations need to comply, arising and in course of employment. Okay, who is an employee? For that, the ESI definition is arising and in course of employment. The word arising is that if a person shows, an employee or a contract employee, whomsoever, shows the intent is enough, that he boarded bus number 13 that takes from T Nagar to Triplicate. He had to get dropped in Anna Salai. I'm talking about Chennai. I'm a Chennaiite. So it's Anna Salai. So for him, if he can prove, or is in case there is an accident, if he can prove, or if his family can prove that his intention was to go to the company only, to the company's premises only, then that he did not start the work at the factory, he did not reach the factory at all, he died in the course of coming to the office, does not come to the favor of the company. The credit, the favor goes to the employee, because the employee can prove that arising and in course of employment. So the same how we can probably, because when we are talking about 5,000 people, getting into Madras Port Trust Harbor, where Adani has got, a huge workforce. So in such cases, arising and in course of employment is something from a data fiduciary, significant data fiduciary. We may think about giving an advisory note with all the caution embedded, so that this word called arising and course of employment will be treated from the labor perspective, the employee perspective, or the deemed employee perspective, and not from a pure play DPDPA Act perspective.
Say, you are talking of a welfare scheme implementation, social responsibilities of an organization. There can be some differences in interpretation of when the employment starts or not. In that context, okay, if you are talking of processing of personal information while the person is traveling in the bus, okay, then that's a different situation. Okay, I think you cannot apply DPDPA to the bus conductor, because anyway he's not going to ask you your name. You are an anonymized person buying a ticket from Annanagar to say Port kind of a thing. For him, it is processing of an anonymized information. So that bus owner or the conductor doesn't become reliable under DPDPA. But yes, I must still say differently. Any accident in the shop floor or the extension, we will give coverage. So social responsibilities are slightly different. Yeah.
So let us also see the General Classes Act, which has got an overriding responsibility, General Classes Act, because all these laws and all, I had to sign the affidavits and I had to fight before the courts.
Agree. Say, General Classes Act will apply when the specified act doesn't make a proper definition.
Correct. Yes, exactly.
Okay, so there are
thank you.
There are exceptions. Yeah, we may have to discuss that separately, exceptions. But as long as you are aware of these possibilities, as a person who is handling the compliance, you are an enriched DPO or an auditor who will apply it as required in the particular context. Okay. I may not be able to give an answer to every context or every situation which we may come across. See, framework can only give.
I said, it's only input I am sharing, not speaking.
Good. I understood. Yeah. Swapnil. Mr. Swapnil has got something to say.
Yes, sir. So, with regards to this DGPSI HR, I had a question. In case if a data principal who is not yet an employee of an organization but has provided his personal data via a job portal or careers page or some other medium, then how does this framework be implemented, or is there any other framework like DGPSI Lite or full that we should consider?
I say,
Such
we are anyway looking at the legitimate use as one of the concepts. And the Act says that legitimate use may apply for processing of information about employment. Now, what is the boundaries of about employment at this point of time? We can only speculate. Okay. Now, this person makes an application to you only for the purpose of employment. So therefore, can we consider that as about the employment, like what Govind was telling, getting into the bus kind of a thing? Possibly so, but this is something which is beyond the current scope of interpretation. We have to look at it as a gray area, okay? But probably if you consider him as an external person, you have to apply. Basically, we are talking of consent here. See, you would get the consent to collect the information, and the actual processing comes after he becomes an employee. Until that time, you are only processing the eligibility criteria of the person. Sometimes you ask him to go through medical examination before he becomes an employee. And you conduct an interview where you put probing questions and collect additional information. All this happens before the signing of the employment contract. But I think it is actually because of the employment only he does all these things. Except on the website, if you have just asked for an application and he just posts an application, maybe at that time it is not clear. But once he is shortlisted and process starts, I think it is all can be considered as about the employment. Perhaps. Okay. Let us leave it at
So
that.
also specification that you mentioned related to contracts between two different organizations. So there are a few HR organizations who provide like who conducts HR related activities for some other organization. So the process is being outsourced in such cases where they collect applications from people, and then so in that case, I think the organization who is collecting the data will be joint data fiduciary, and the one where the person gets selected will be a data fiduciary.
Possible, yeah. That's one of the three contexts which we have identified. Yeah.